Right, so I think it's time to start. Thank you everyone for attending. I'm Felicity Gerry, Queen's Counsel, member of Libertas Chambers. This is the next in our series of webinars that we hold once or twice a month. We record these webinars, so thank you to all of those of you who've been able to attend. I think we have about 45 people registered for this webinar, and I'm sure we'll get lots of people listening to the recording afterwards. The topic today is challenges for victim participation in international criminal courts. And today we're presenting the research of Dr. Rudina Jasini on the role, scope and implications of victim participation in international criminal proceedings. And in this webinar, we're going to discuss the importance of this research to all counsel, including those acting for the defence. Dr. Rudina Jasini is an attorney and researcher specialising in international criminal law and human rights law. As an economic social research council researcher at the Faculty of Law, University of Oxford, she's led the ESRC project called Advancing the Impact of Victim Participation at the International Criminal Court, Developing Avenues for Collaboration. And she did that in cooperation with the International Criminal Court Bar Association. In addition, she was a postdoctoral global fellow at New York University Law School Center for Human Rights and Global Justice, and visiting scholar at Harvard Law School and the Max Planck Institute for Foreign and International Criminal Law. She is currently a co-counsel for one of the accused in the Hague et al. Case before the Kosovo Specialist Chambers. And I've known her for a number of years. In my view, she's a genius and her research is superb. So we're very, very lucky to have her. Over to you, Ina, on the role, scope and implications of victim participation. Thank you very much for joining us.
Thank you very much to you, Felicity, for this very, very kind introduction. I would like to express my gratitude to the Libertas Chambers and particularly to you for this kind invitation, as well as all of you who have joined us virtually in this webinar and for offering me a platform to talk about my research and more specifically about the implications of active victim participation in international criminal justice. If we could go to the next slide, Felicity, I just wanted to start my presentation with a quote that marked the beginning of my research, really, almost 9 to 10 years ago. This is an excerpt from an interview I had with a victim of the Khmer Rouge regime in Cambodia who had been recognized as a civil party in the first case before the extraordinary chambers in the courts of Cambodia. The person sitting in front of me was a victim of the Khmer Rouge, a stakeholder in the proceedings. He had come for the first time, had been recognized for his harm, grief, and suffering, and had been included as part of a transitional justice mechanism that was allowing for a different role for victims of mass atrocities compared to the role that victims had played, let's say, at the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, Special Court for Sierra Leone, where victims were granted the status of victim as a witness. So this was in a different capacity. The meeting took place in a pagoda, in a shrine, which for many victims of mass atrocities in Cambodia had come to symbolize a meeting point for the survivors and a place to honor the memory of those lost. His very painful and powerful words reverberated not only across this sacred place, but also through my head, and trying to understand for the first time outside the architecture of a courtroom what it is like to be in contact with victims of gross violations of human rights, to have a discussion, to build a rapport, first of all, to understand how they perceive their role in any transitional justice mechanism, and more specifically within an international criminal tribunal such as that of the International Criminal Court or extraordinary chambers in the courts of Cambodia. But in a way, what he was expressing brought victims the magnitude of their suffering ever so close to my understanding why it is so important that in the context of mass atrocities, we look for forms to make victims feel they're part of the process and they're stakeholders in these proceedings. And this marked the beginning of my research. At the time I joined the first team as a pro bono lawyer. I joined the first team who had led by the current chief prosecutor of the ICC, Karim Khan, who at the time was representing victims in the first case before the extraordinary chambers in the courts of Cambodia in the Doik case, if you may have heard. Further on, in the next slide, you will see how I embarked in this journey of research. And the next slide will show actually a meeting that I had 4 years later as part of my DPhil or PhD program at the University of Oxford, where I interviewed 112 victims who were participating and were granted the right to participate as civil parties in proceedings before this court. I organized focus group meetings, but also I held one-on-one interviews with them, and in-depth interviews that took several hours to fully understand what were the motivations behind their participation and what they were hoping to get out of this process. In the next slide, I will talk more specifically about the development of victim participatory rights in international criminal justice. Undoubtedly, the recognition of victims' rights in criminal proceedings is a novelty in international criminal justice, and it is considered an advancement to the victims' rights. This development, which was evidenced throughout 1980s and 1990s, was the product of parallel advancement on both domestic criminal justice system and also international criminal justice system towards greater acknowledgement of victims' rights. And it was a response to the growing criticism of the victims' rights groups and organizations that concern the apparent marginalization of victims within the criminal justice process. These pronounced trends at the international level was first reflected at the Rome Statute, which led to the establishment of the International Criminal Court, which offered victims a characterization as victim participant. This role was further heightened at the extraordinary chambers in the courts of Cambodia that granted the victims a status of civil parties and made them like a third party in proceedings, although that does require some interpretation because it doesn't fit the classic role of parties as we know in a criminal justice process, that of the prosecution and defense. But this trend has continued with the Special Tribunal for Lebanon, and it's also a feature of the Kosovo Specialist Chambers, which is this newly established justice mechanism that's supposed to be a local Kosovo court, but that the way it is operating is entirely almost an international court. And the feature of victim participation or this legal mechanism has found expression, although we are at the very beginning, so we are in the pretrial stage in the case that I worked on. So we will wait to see how the judges are going to shape the role and scope of victim participation. But what is very important to know is that this advancement of victims' rights, which has the beginning in, or it's more pronounced in civil law jurisdiction and less so in the Anglo-Saxon and common law countries, has seen a development also, like parallel development also in the domestic criminal justice system in both legal cultures, let's say. The European Court of Human Rights and its jurisprudence has something to do with it. Also, the extensive procedural rights that were granted to victims with the ICTY and ICTR, the Tribunal for the Former Yugoslavia and for Rwanda, also put some emphasis on the procedural rights of victims, although it did not recognize, this court did not recognize victims as civil parties at the time. But in this context, we also had an acknowledgement of the UN with two important declarations. The first legal instrument was the 1985 United Nations Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, that is known as the Victims Declaration, with a focus primarily on victims of domestic crimes. And secondly, in 2006, the UN adopted a resolution that is known as the Basic Principles and Guidelines on the Right to a Remedy and Reparation for Victims of Gross Violations of international human rights law and serious violations of international humanitarian law, which for all practical purposes is known as the Bill of Rights for victims of mass atrocities or victims of international crimes. In addition to the influence and the progressive development of jurisprudential development at the Inter-American Court of Human Rights, European Court of Human Rights, it became almost apparent and evident that we ought to think in a different way when we talk about mass victimization and how we can find ways to include victims in this process. In 2008, there was a conference that took place at the ICCBA that was focused on the legacy of the ICCBA. And it was fascinating because for the first time, the judges, prosecutors, defense lawyers in that court came face to face with victims groups that came from the former Yugoslavia, who made it clear that the justice rendered in The Hague was not necessarily perceived and received as such by these victims groups back home, and something needed to be done. So in light of this development, the ICC and the drafters of the Rome Statute decided to adopt this new legal mechanism which is known as the victim participation or civil party participation, which technically means attaching a civil claim to a criminal process, although at the international sphere, international criminal justice, it takes a different form and it poses some significant questions that are unique to the nature of trial for war crimes, crimes against humanity, and genocide. With regard to victim participant status at the ICC, what is very interesting is that, as some of you, or maybe all of you know, that the ICC operates on the basis of situations. They carry out investigation in a particular situation in a country or neighboring countries, depending on the nature of the armed conflict. And what has happened is the decentralized nature of the interpretation of victim participation that the ICC has shown has meant that within the same situation, you may have two different cases where judges have approached victim participation differently and have marked, let's say, or demarcated the parameters of victim participation according to their understanding of victim participation, and to be honest, who the judges in the trial chamber, which countries they were coming from. If it happened that you had a judge from a civil law jurisdiction, he or she would have a far more favorable approach to victim participation compared to a judge that would come from a common law, where the role of victim is seen always after a conviction is rendered, and you could extend a participation of victim through a victim impact statement or similar nature, but that's the case in England and Wales, in the UK, also in the US, Australia. So you don't have that full participation that it's known or it's classic in France. In the case of Cambodia, where civil participation, because of the reliance on the civil law jurisdiction and being a former colony of France, there was a closer understanding. So almost the French lawyers who participated in crafting this mechanism that was known as the extraordinary chambers in the courts of Cambodia decided to come up with partie civile, as they call it, full party. And it proved quite problematic in the first and second case. And I will highlight some of the things or like shortcomings of victim participation in the first case and the second case as well, although it was streamlined and they tried to rectify some of the shortcomings and mistakes that were evident in the first case. Is it meaningful participation for victims of mass atrocities to have their names, only their names included in the judgment at the end, where for about 2 years or so, they were invited to be part of a process and with high expectations that, and that expectation was more so linked with the right to a reparation, which in the case of the court in Cambodia, the reparations were designed to be collective in nature and symbolic, so it didn't have any form of financial reparation or individual reparation per se. But victim participation was not even funded. So imagine this, you have a court that allows for 3 parties to participate in criminal proceedings. 2 parties are fully funded. And of course, the accused through the legal aid program, they had international lawyers who participated and I represented them, who were paid justly so for the work they did. Meantime, victims were left to their own devices. And in the first case, you had 4 different legal teams trying to assist victims in Cambodia. One team was the team that I worked on pro bono, and everybody was pro bono, international lawyers. One was Avocats Sans Frontières from France. One was a project of GTZ aid program from Germany that brought its own lawyers to assist the 3rd group of victims. And the 4th was a local NGO supported through human rights organizations in Cambodia. Having seen what happened there and the massive disappointment that victims experienced with regards to reparations in the first case, the court tried to streamline the participation in the second case. In the second case, we had 4,000 victims. And by design, allowing for full funding of victim participation, having 2 lead lawyers, 1 Cambodian and 1 international lead lawyer to represent victims' interests. But this proved quite interesting, and I would like to kindly ask you, Felicity, to go to the next section that talks about this, what I call a balancing act between civil party participation and equality of arms, which I believe would be of interest to defense lawyers here, especially because it poses some really unique questions that deserve answers. And when I embarked on this project, I had an enthusiastic outlook on victim participation. After several years of research, I must say I am ever more so reluctant and skeptical about the form of victim participation that is being allowed. And I will explain a little bit more in detail what I mean by this, a balancing act. In one of the interviews that I conducted was with a judge, a New Zealand judge, who was, in the first case, driving force behind the bench, Judge Sylvia Cartwright, who in the interview, she said, there is perhaps no stronger affirmation of the power of victims' voices in criminal trials when that power comes from the victims themselves. Any lawyer and judge will tell you that the dry words of an indictment charging an accused with serious crimes come alive when the victim speaks in court. Most significantly for me, the victim testimony gave a real vibrancy to the history of the regime and took us all back to the country as it was in the 1970s under Pol Pot's leadership. This level of recognizing this imperative, let's say, principle of criminal justice, the raison d'etre for having these mechanisms in the first place, which is justice for victims. But when you see it in practice, and especially when I interviewed a legal officer, senior legal officer assisting this particular judge, who said, to be honest with you, this is far more of a reactionary, disappointing development in international criminal justice, because there is no single issue at this court that has gained as much attention as the issue of participation. And now, as she said, I'm often a bit puzzled when this is described as a very innovative and groundbreaking. To me, it is the most conservative reactionary system you can imagine. there was no creativity in setting it up. Basically, it was incorporating wholesale the civil party system as it exists in France, where we always have very few victims or partie civile, into this environment here. And what we are facing is a mess, she said. We don't know what form to give to this. The prosecutors, on the other hand, then you think that the victims' interests or legal representation of victims, their interests would be more in line with the prosecution case. But the prosecution has a strategy in place to establish accountability. They don't want a party that takes over after they finish their examination in chief, asking witnesses and expert witnesses, and perhaps taking the lead or giving an opportunity to the defense to rectify on some of the mistakes made by the prosecution, or a window where, a lead that the prosecution may not be very comfortable with. The defense lawyers, on the other hand, although sympathetic to the needs of victims to participate and their rights, felt that they're facing two prosecutions, double amount of motions, and it kind of has a burden on the process as such, because the accused, who is presumed innocent, has the right to a fair and expeditious trial. So these were all very paramount, I would say, needs that a criminal trial, or the principles of a criminal trial, how it operates and how it should operate. And so basically, at the time, and it still is the case, and I will explain a little bit about the ICC as well, where you had one implication was prolongation of court proceedings, and it's unavoidable. If you have another party asking for witnesses to be called, calling expert witnesses, posing questions, writing motions, making requests, this will lead to a further delay of the court proceedings and prolongation of the case as such. But you had issues with disclosures, and this was pointed out by both prosecutors that I interviewed and also defense lawyers. Prosecutors would say, and the defense lawyers pointed exactly at this thing. When victims, you can never have 4,000 victims participating their views in the court. There will always be representation or certain representatives of these groups. But they're prepared or briefed or probed by their legal representatives. And most of the prosecutors and defense lawyers say, well, in the course of their preparation, they are gathering information which, according to the state statute and law, they're not required to disclose. So here is one particular issue with disclosing anything that could be exculpatory in nature. There are effects on prosecution and defense, as I described, but there are also some unintended effects on victims. And one points to a more philosophical question. In a nation where you had more than 2 million people killed, 1/4 of the population at the time, even though you may have 4,000 victims, this represents a very, very small percentage and section of victims. And who the victim is, that's another question. We talk about direct victims and indirect victims. Recognizing some victims at the exclusion of others may also lead to some societal issues in this post-conflict society that needs the reconciliation and the need to move forward as a society. In Cambodia was interesting because the court was established 35, 40 years later, but in most other courts, and I don't think there is going to be a court soon on what is happening in Ukraine, but it's most likely there will be a mechanism that will deal with these crimes at some point. All the courts that have been established, with an exception of the ICCBA, Extraordinary Chambers in the Courts of Cambodia, have been shortly after a conflict had taken place. And so you have to think of these big objectives that any transitional justice mechanism tried to achieve: seeking justice, seeking truth, fostering reconciliation, as well as addressing the victim's needs for reparation as such. If I could move to the next slide, Felicity, thank you. In the interviews that I conducted with victims, which was by far the richest part, I would say, of my research, I tried to understand how they understood their participation and what their motivations were. And it was quite interesting because some of these interviews, the majority of them were conducted in some of the most remote areas of Cambodia. And I found their views quite not only interesting, but moving in many ways, because you think like, here is someone sitting here who has perhaps never even been to the capital and is telling me about the need to educate the world so that the world knows that what has happened here should never be repeated anywhere else. The first one, which relates to the idea of seeking truth. The victim's understanding of seeking truth is not necessarily only linked to pursuing a guilty verdict. It's kind of more intertwined with the second and the third pillar, which is seeking truth, telling one story. And in this context, many victims would express that, for example, I was a direct victim of the Khmer Rouge. My participation as a civil party is very important for two reasons. First, to seek justice for myself and for my relatives. But second, help the system to provide inculpatory evidence towards establishing accountability. I want to understand why this happened to the Cambodian people. See, this idea of seeking truth was so closely aligned with their understanding of justice. Even though they knew very, very clearly that the person who is standing accused is not necessarily the person who committed the crime. These are people who are in the higher echelon of the political structure and military structure. And still they wanted to see and face it. And some of them would even ask, like, why did you do this to my family, to the Cambodian people? This is important for us to know. Telling one story. This was a very interesting motivation because there was a perception out there that victims had in the beginning that, well, I will sit there in the courtroom, everybody will listen to my story. In fact, the prerogatives of the trial were such that it made it very difficult. The limitations of the criminal process are such that, and procedure, that victims quite often only answer questions put forward to them. They couldn't tell their story in a narrative form, which would find better expression in a Truth or Reconciliation Commission or Gacaca court, like in Rwanda or other courts. Another interesting aspect was educating the world, as I mentioned, which was mentioned by so many victims, like, we want the world to know what has happened here and for never to be repeated. And of course, the last one, which was seeking reparation, was by far the most contentious, disappointing aspect of victim participation. In the second case, the court couldn't award the kind of projects or requests for reparation that victims have put forward that were entirely within the remit and the obligation of the state. For example, victims have asked for access to free healthcare. And they would say, like, well, if a person is accused, is found guilty and is in jail and gets sick, he will be treated. I am so poor, and the level of poverty there is at a whole different, you have to touch it sometimes to understand how, and it's relative, the notion that we have about poverty, but it was really extreme. So you could say that, but of course, the right to free healthcare is a very legitimate request for people who have lost 35 members in their extensive family, and the immediate family completely perished. And the court was bound by limitations that they could only award projects that were implementable by the court, or they couldn't award things that were entirely under the responsibility of the government. And so reparations continue to be disappointing. It's been disappointing at the ICC as well. Bemba case was one such case, a high-profile case where an accused, number 2 of the Democratic Republic of Congo, was found guilty by the trial chamber, decision quashed on appeals. And what happened to the right of victim to participate and their forms of reparations? But in conclusion of several years of research, and I am looking forward to publishing this as a book. So I'm in the process of putting a book proposal these days. I found that while victims have taken advantage, and this will be the next slide, Felicity, while victims have taken advantage of their procedural rights at these courts, their role remains largely symbolic. and they have yet to realize their substantive rights. The interviews that I have conducted with them, but also the project that I led with ICC, showed pretty clearly that there are limitations and inadequacies that the courts have with regards to granting victims substantive rights. And this relates also to the right of the accused of an expeditious trial, presumptions of innocence. So how do you balance that in such a way that you honor these principles of criminal trial, but at the same time try to accommodate this new mechanism that gives victims greater rights? If courts need or foresee victim participation to be a feature of, as it is now, and the trend will continue most likely, then it has to think very carefully how we address victim participation on a normative level and a legal level. So it has to start first and foremost from a normative standpoint before we design this mechanism that are maybe perceived cumbersome and actually do create certain pressure on the process. And we leave too much room to the judges trying to navigate and interpret the role of victims as almost like they're having a carte blanche in this court. The second point, and that's the next slide, is that if ICCBA and other international criminal tribunals afford victims the right to participate in proceedings, it is imperative that they develop a very sound statutory and procedural foundation from the very beginning to shape or to allow judges to shape victim participation in the courtroom. Legislation as it is, like for example, the Kosovo Specialist Chamber has given one of the broadest, the most generic definition of victim participation. And I can foresee beforehand, before the trial starts, that the judges are going to struggle on how they navigate through the issue of victim participation. And the third point is that the implication of the civil party participation has shown that any effort, and that's my third point, Felicity, the implications show that any efforts to valorize expanded participatory rights by affording victims a role beyond that of a victim witness or victim complainant demands first and foremost a careful understanding of whether increased participation is in the best interest of victims and in the best interest of justice more generally. We need to develop a realistic understanding of the potential shortcomings of civil party participation could have with regards to the objectives of fairness, functionality of court proceedings, and victims' needs and interests, and most importantly, to avoid re-victimization at all costs. My fourth point is that what has emerged thus far in the way victim participation has been dealt with, and that's my next slide, is that there is a degree of reluctance by judges, prosecutors, defense lawyers to fully embrace this mechanism. Maybe because many of them had never had experience and they were hesitant to how best to embrace it in a way. So this can only work only if the legal community fully embrace victim participation and allow for it to, and that if you are working in a court that has victim participation and you are a defense lawyer, well, in a way you are bound to play by the rules of the game in that court and to not only be sympathetic in principle, but also to understand where it's coming from. And it's of a different nature. I've seen the struggle that some defense lawyers have in this court. My fifth point is that in the next slide, courts should not afford victims greater participatory rights unless they provide adequate and full funding. As I said, this can only work if you have, the success of this, if I could call this a success, can only be predicated on a well-functioning practical legal framework, reception by participants, and sufficient resources. And my last point, and this will be the fifth and the next point, Felicity. My last point is, and I don't want in any way to hamper down the need or to acknowledge all this development, but I ended with a sense of caution, saying that even though this is in its nascent stage on the international scene, its application has been therefore quite fluid, at times vague and contradictory. There is a critical need for well-developed common standards at both legal and normative level to guide the application in principle. It would be unwise for international criminal tribunals to expand the scope of victim participation beyond what the court can deliver. The inherent nature and structure of the legal process is such that any participation of victims could find better expression, perhaps, in non-legal mechanisms. So if there is a need for transitional justice mechanism, then maybe we have to think for mechanisms that complement each other, where victims could tell their story more narrative way, like a little bit more cathartic, and trying to understand the needs of them in the context of a post-conflict or conflict society, as it is the case now in Ukraine, and Syria, and Yemen. So the list goes. But these are overall my research findings, and I hope you have found this presentation enriching and interesting, and maybe have given you some food for thoughts. So I would welcome your questions.
Thank you. Yeah, look, it's really interesting. And I think that what comes out of it, for me at least, listening to you, is the sort of failure to recognize the need to have a court that recognizes its own accountability function in relation to the situation. So although you've got an individual on trial, a large proportion of what the court does is make findings that the situation occurred and there were victims. The question for the individual is whether or not that individual is responsible. But if the courts are truly going to work as an accountability mechanism, a lot of those findings are about, well, it actually happened. These atrocities actually happened, and therefore victim participation has an important role and needs to be meaningful and effective on that question before you even get to whether or not they can give evidence on the role of the individual who's on trial. So I think there's, it sounds as though there's sort of been a failure to recognise that the findings on the situation itself require victim participation over and above the individual evidence in relation to responsibility of whoever it is that's the accused person. And that was something that was quite a challenge when recently I presented an Amicus Curiae brief in the Dominic Ongwen Appeal, and our brief observations were related to the non-punishment principle. So Dominic Ongwen, a former child soldier, his defence essentially was trying to use the defence of duress to say that he had a mental incapacity that limited his responsibility for the crimes and or meant that he should have a reduced sentence. That's a very short version of what's a very complicated appeal. Now, our point was, well, what is the mechanism and what are the legal frameworks for former child soldiers? Is it merely the defence of duress, or can the defence of duress be interpreted to include what we might call duress of circumstances? And where child soldiers are recognised to be a form of trafficked persons, to what extent does the non-punishment principle apply, that we don't prosecute trafficked persons who commit crime as a direct consequence or where there's a nexus with their trafficked status? So for my part, I thought it was a really interesting observation that we made, because the trial chamber had applied no jurisprudence whatsoever. So we were asking the appeal court at least come up with a legal framework. You know, it might not make a difference to the outcome for Mr. Ongwin, but there ought to be a legal framework that we can work with about when you don't prosecute or you don't punish what we might call a victim perpetrator. And it was really interesting. It got quite heated during the sentencing submissions of the prosecution, the victims groups and the defence, which we were observing by that stage. We'd made our submissions. And it was a representative of the victims groups who said the non-punishment principle should not exist in this court at all. And I found that really shocking, because I thought, well, a lot of the people you represent might not be just victims, especially when you think of how wide co-perpetration or joint criminal enterprise can be. It'd be very easy to accuse someone of being an accessory in some even small way. And then you'd end up with an argument about whether they're a victim at all. So you need a legal framework. And it was pretty shocking to me that that was a submission being made by a victims group, some of whose clients might well be former child soldiers, potentially at risk of prosecution. So I'm not saying that's true of their particular clients in that case, but it seemed to me there was a real failure to think about the value that victim participation can have for those people who may have also contributed in some way to the situation that's occurring. And I also think that your research is really interesting for those of us who work in the realms of universal jurisdiction. So quite a lot of discussion now around domestic prosecutions for international crimes, and how are we going to accommodate victim participation in those types of prosecutions if cases are brought in England and Wales or in other jurisdictions that have had less appetite for universal jurisdiction. And certainly there are cases in Europe, and I don't know that victim participation is being dealt with particularly well, and there's much more of a focus on the individual responsibility. So I think there's some discussion to have around that. And then thirdly, to think about the way in which we deal with victim participation in domestic courts. Correct. And a couple of stories before I ask you some questions. I always like to give a bit of a chat before we get to questions, because it gives our audience time to think of questions. But two examples that I can give in a domestic context are a comparison. It's totally anecdotal, but in two cases of mine, one in England and Wales and one in Australia, that involved what we call victim impact statements. Now, in Australia, it was a case involving harm to a child, and that one parent was being prosecuted and the other parent had been given what we might call custody or residence of the children. But there was a background to the conduct by the accused person that came from domestic violence from that other parent. So there was a real question about the role that parent would play. Anyway, there was a victim impact statement, large proportions of which were not relevant to the issues. It was an expression of how that particular person felt. And the issue was, you know, the effect on the children. In fact, it was agreed that the children had no memory of what had happened and had not been specifically affected by that, probably more affected by being taken away from their mum by the legal proceedings. But so the judge in that case ruled that most of the victim impact statement was not admissible. And there was only a small proportion of that evidence that was allowed to be admissible on the question of sentencing the mother. Conversely, in England and Wales, a sentence after a murder conviction where my client was an autistic child who was 14 by the time of sentence, and the judge had acceded to a submission of no case to answer. So the murder had gone and the child was being sentenced for manslaughter. And yet the victims were allowed to go into the family members of the deceased were allowed to go into the witness box and label the defendants murderers. These murderers have taken away our relative. And they were obviously very emotional and distressed, but it was inaccurate. And there was no control whatsoever over the content of the victim impact statement. So it struck me sitting there listening to that actually this wasn't meaningful participation from anybody's direction. Both of those systems didn't seem to work. and weren't restorative at all, and actually raised the temperature and ended up being a sort of mechanism to attack rather than anything that would involve some form of reconciliation. So I think your research is really interesting on those respects. You know, what do we actually mean, and how does that participation occur without actually making things worse? And finally, I suppose the last example that I can give in this circumstance was, I first thought about it, maybe it wasn't the first time I thought about it, but I thought about it a bit in relation to Nigella Lawson, when she was giving evidence in the fraud trial as the person who was alleging that her staff had defrauded her or stolen from her in relation to personal possessions and finances. They were acquitted. And afterwards, she'd had to put up with terrific media attacks and all sorts of dreadful behaviour on her way into court. She was really on show. Very, very difficult experience for her, I accept. But Geoffrey Robertson wrote an article saying she should have had her own lawyers and a form of victim participation like the international courts. And I wrote a rebuttal saying, well, hang on a minute, you know, we've got to be able to we can't say that all women are vulnerable, all women have to have the agency to stand up and say, look, I was defrauded. This is what happened to me and you need to deal with it. And we need to give women the confidence and the agency to stand up and give that evidence. But over the years, I've thought, you know, actually, it was a pretty rotten experience. Doesn't really matter what the outcome is, but we probably need to be much more trauma-informed. So now I write about trauma-informed courts. So I hope I've rattled on long enough to generate some questions. I know there's one in the chat. So if anybody wants to ask a question, if you could use your little emoji hands, and then I can come to you. Ina, I'm going to ask you the one that's in the chat because Cheney has a poor connection. So her question is, to what extent is there any overlap between individual domestic right to review or constitutionally challenged shortcomings in the handling of their case and similar protections at international level? I think she's probably typing on her phone with poor Wi-Fi, but I hope that means something to you.
So if I understand this correctly, is whether there is an overlap between individual domestic right to review. Okay. Now, the context of victim participation in the international scene is most of these victims would not even have a standing to request, for example, a right to review or constitutionality challenge before the domestic courts. So for them, the avenue through which they hope to have a say in the process that is different from that as a victim witness and hopefully to gain some form of reparation would be through victim participation. These courts are hybrid and ad hoc by nature. So if is the question, and I wish, you know, I understand you have poor connection, but when you say any similar protections at an international level, protection for victims, you mean those who participate? Because I can mention one thing, for example, and it comes down to what we discussed, whether the participation is meaningful. On the statute, a victim needs to make a decision from the very beginning whether he or she, if called by the prosecution, want to be a victim witness or a victim participant. The differences, there are many differences that are linked to this, but a fundamental stark difference is a victim witness testifies under oath. Therefore, her testimony in the overall assessment by the judge carries a different weight compared to a victim participant who may tell a very strong, you know, story and narrative. So in that case, when you say protection, the court accommodates victims' interests and needs in two forms: victim witness and victim participant, if the statute of that mechanism allows so. If you could help me a little bit, Felicity, because I want to understand a little bit better in terms of protection or the right to review or constitutionality challenge at an international
I don't know if we can hear from Cheney. Cheney, can we hear you, or do you want to just type a little bit more? just so that we can flesh out what you mean by your question. If you have a go at that, Ina, I'll just think we've got another question for you. While we're seeing if Cheney can give us a bit more information, perhaps you can help us with this one. What are the unintended effects of the civil party participation on that you told us about on victims? And what's the impact on this participating and non-participating victim, so that we can get our heads around those concepts when we're thinking about how this might be meaningful without unbalancing the fairness of a trial for an accused person.
Correct. And following what I mentioned and highlighted before, the fact that you may have 4,000 victims in a nation where you had more than 2 million people killed poses some not just philosophical, but truly societal questions that needs to be addressed. I interviewed both participating and non-participating victims, and fairly so, the non-participating victims expressed their views that the fact that the prosecution designed or came up with an indictment that included this village as a charge in the indictment, but the village, the neighboring one where I am, is not part of the charges, doesn't mean that I didn't suffer from the same regime. Doesn't mean that I was not subjected, me and my family and everybody I know, to the same harsh would be an understatement, horrific regime. And that is a very legitimate concern when you think of, how have these victims perceived victim participation as such. Unlike other courts, Cambodia, because the court was established and is functioning and it's operating from Phnom Penh, allowed for the largest form of public gallery audience compared to any other court. So the society in Cambodia was so invested in knowing more and more about the case, the trials, and interestingly enough, when the concept of victim participation, because it didn't come from within, there was a lot of work done by human rights organizations to prepare the terrain on the ground and to educate victims that here is this new mechanism that you can apply, but you need to submit a form to do that, to be taken into consideration. And so many people applied, and very, very few were granted the status. And so those who were not granted the status, there was a degree of disappointment. So you needed almost another form of education to tell these people, listen, they're representing all of you, but yes, he said, or she, they will get reparations and I don't get anything. And I'm not even allowed to tell my story. And I have so much that I can say about this. So there is this effect that we ought to address between those who are recognized. And even in the second case, the judges made a broader interpretation between the harm suffered by these individuals and the charges brought against the accused. So the link was a little bit more loosened than the first case. Technically speaking, it is very hard to prove direct link for some of these individuals because you had, like, for example, the Minister of Finance or Defense who masterminded part of the regimes and what happened, but who was not necessarily the person who committed the crimes. And this comes down to what you discussed before, Felicity, with regard to command responsibility, joint criminal enterprise. So there are so many questions that need to be addressed there with regard to victim participation, but this is one of them. Some unintended effects, and of course, unintended effects also on the victims who participate to avoid re-victimization. So you don't want these victims who come from villages and communes and areas that come with such vested interests, travel long hours, sit there every day, participate, have to recall very painful past, only to be told at the end that, by the way, some of them lost their status halfway through the trial. That's another massive blow. because the judges decided in the first case to go for kind of more narrow interpretation and that link between harm and
so I think I'll just bring Cheney back in here because she's got poor bandwidth, but she has clarified what she wanted to ask, which is what's really the mechanism to review those decisions. If judges make a decision to actually say, well, you're no longer a participant, what can victims do to challenge that is her question. How do they appeal that decision or review that decision? Is it a JR process or I think she's trying to understand the process of challenging those types of decisions.
And I understand that you come with this question from a very domestic criminal justice perspective, where you have either high court or constitutional court that addresses these three issues, or even appeals court that, so the law allows you to go to a higher court. In the case of ad hoc hybrid tribunals, you may have appeal chamber within that institution. However, the statute is designed in such a way that you losing your status as a victim or not being granted the status in the first place, it's because you didn't meet this threshold, this requirement. It's not necessarily to not acknowledge that a harm was done to you. It's just that harm, it's not linked very strongly to the charges. And so I'm afraid to say there is not a review process per se. It comes down to a far more administrative process in the first place by a victims units section of the court. You submit a form and they see it like none of the things that you say were committed, not even close in the area that is part of the indictment. But then some go through the pretrial stage and the judges sit there, and because they're kind of demarcating the boundaries of this whole case, some streamline the case, make it narrow. They could ask the prosecution to focus on, because the justice demands that we also be fair to the accused. So the bottom line is, I'm afraid there is not a judicial review process per se at these international criminal tribunals.
But it's something we could think about domestically, couldn't we? And what would be the process if you decide to have, let's say, a universal jurisdiction case, so you're prosecuting an international crime in a domestic court. When we think about what will the role for victim participation be, would there be a review process for those types of decisions in a domestic court, where there are sometimes certain review, very few, I must say, domestic criminal court, but something, again, to think about and hurt our brains, stretch our brains on how you might create some form of hybrid in domestic proceedings. We've got another question here. Taking the ICC rules as an example, do you think that extending, or at first instance clarifying, the definition of what constitutes a victim and what causative links are required to be involved in proceedings would assist in increasing victim participation?
And that's the crux of the matter here entirely, because it's one thing for victims to apply, and it's another thing, and as I mentioned, you may have the case, who the victim is. This is a big, massive question. How we define victimhood? And we understand that so many people have suffered you have mass victimization, but you have also mass perpetration. We designed this court to try those most responsible for the crimes committed. And then we try to bring victims of this regime, genocidal regime, crimes against humanity, linked to a case. And so it has happened that within one situation at the ICC, you may have two cases where victims' right to participate have been dealt differently, because the judges who are sitting in that particular trial chamber have a certain vision and understanding. And it should not be like this. It should not depend on the legal culture of judges or their individual understanding. It should be on proper jurisprudential, development that is based on normative and strong statutory law. In that case, I'm afraid to say it's not just decentralized. I call it experimental laboratories. Sorry, but that's how it has been thus far.
Yeah, let's call it a learning curve for today. The courts are learning but learning very quickly, and not terribly restorative, and not creating any level of reconciliation either. So there's a bigger question for the functioning of these international courts and how they might function better. I think the window into victim participation that you've given us into your research today allows us to also have that bigger think as to how these international tribunals can retain integrity as well as and legitimacy, and have that sort of buy-in from both sides, from those accused and through that lens of victim participation in relation to a situation. Look, I think we've reached time. We did an hour, so we've done it, 5 past to 5 past. So that was very, very timely. Fantastic to hear all your research. Thank you so much for giving up your time to us this evening. And thank you for everyone who's attended. A reminder that this is recorded. So, so we will put it out on the webpage soon. Our next webinar is, I think, the 23rd of June on art law, organised crime and the digital marketplace. I've summarised the title, but art law, international art law, which I think will be really interesting with Dr. Jonathan Harris. So it only remains for me to say thank you so much, Dr. Rudina Jasini. We're all very much looking forward to your book when you get to it. So good luck with all the hard work that comes with producing a book. And thank you so much for stretching our brains this evening to think about victim participation in international criminal courts and how that's important for all counsel, including those acting for the defence.